interstate relationship, the successful functioning of the Indian federal system depends not only the harmonious but also cooperation between center, state, adjudication, coordination, mutual recognition for the acts and freedom of interstate trade. So there is the interstate water dispute 262. Parliament may by law provide for the adjudication of the dispute complaints with respect to distribution of control and water. Parliament may also provide that neither Supreme Court or no other court is exercise jurisdiction in respect of this dispute. Under the provision, Parliament has enacted the River Board Act. That was the River Board Act 1956, State Water Dispute Act, and the River Board Act provide for the establishment River Board for the regulations and interstate river water valley. A river board established by the central government on the request of state government. Interstate Water Dispute Act empower the central government to set up the tribunal for the distribution of the two river, and the decision tribunal would be final and binding, and it is binding. So on the parties of the dispute, neither the Supreme Court nor the other court to have a jurisdiction in respect of the water dispute. The need for the extra judicial machinery to the interstate dispute, a Supreme Court would indeed have a jurisdiction to decide any dispute between this. If legal rights or interests are the concern, but the exercise of most country has shown, and so far 2016 the central government has set up the interstate water dispute tribunal and constituted the state involved. So now there is a Krishna Water Tribunal and Godavari Water Tribunal, Narmada Water Tribunal, Ravi, Kaveri, Vansadhara and Mahadai. Interstate Council, that was 263, contemplate the establishment of interstate council between the state and the center. This president can establish such a council if at any time appear to him the public interest, even though inquiring into it, advising upon dispute and investigating discussion subject which is state or the center and the state have a common interest, making recommendation upon such subject and the partially for the better coordination. The council function is to inquire the advice of interstate dispute to the Supreme Court jurisdiction of Article 161 as a legal controversy between the government, can deal the controversy whether non-legal but function advisory. Under the above provision of the Article 263, President has established following council: the Central Council of Health, local government, 4 recognized council for the taxes. Establishment of interstate council. Sarkaria Commission of Interstate Relationship made a strong case for the establishment of the permanent interstate council. 263 of its recommendations are the differentiate the interstate council and called the interstate intergovernmental council also. So Prime Minister is the chairperson, Chief Minister, CM of the other territory and the administrator of this territory. VP Singh established this council, and that was 1990. Governors and the 6 central cabinet ministers including the Home Minister to be nominated. 5 ministry of the cabinet rank of the state nominated the chairman. The council is the recommendatory body or issue relating to the interstate, center, state and central union territory. It aims at promoting coordination term and examining, discussing the deliberation issue, investigation and discussions of subject which is state center have a common interest, making recommendation upon such subject, better coordination and general interest to the state as they may be referred. So council may meet at least thrice in the year. Meeting are held in the camera. There is also a standing committee of the council, 96 for the continuous consultation. Home Minister as a chairperson, 5 cabinet minister and the 9 chief ministers. So the council assisted by the secretariat called the interstate secretariat in 1991. Public act and the judicial proceedings. So under the constitution jurisdiction of this each state, possible that act and records are not be recognized in the another state. To remove such difficulties, constitution remain the full faith and credit. Full faith and credit is given throughout the territory of India. So that is includes the legislation and executive act of the government. Public records include the official book, registered records, and manner and condition under which such as records proceeding are to be proved. Effect determining would be provided to the Parliament. Final judgment of the order at India is capable of executing within the India. The rule applies only to the civil judgment and not to the criminal judgment. Interstate trade is 301 to 307, and that is part 13 of the Constitution. The Constitution deal with the trade, commerce, and intercourse territory. 301 declared that trade, commerce, and intercourse throughout the territory of India shall be free. The object of the provision is to break down the border barrier between the states and create one unit with the view of encourage the free flow of the trade, commerce, and the intercourse. The freedom under the provides not confined to interstate trade, but this Article 301 will be violated whether a restriction are imposed. The freedom guaranteed are is freedom from of the restriction. The Parliament can impose the restriction freedom of the trades, and the Parliament cannot give the preferences. The legislation of the state has a impose the reasonable restriction on the freedom of the trades with of state or within the state, but a bill for purpose can be introduced in the only the previous section of the President. The legislation of the state can impose on the goods imported from other state or the union territories similar good manufactured in subject. This provision prohibits the imposition of discrimination taxes. The freedom of is subject to the nationalization of law providing the monopoly in the favor of center. So the parliament or the state legislation can make law for the carrying on the respective government of the trade and businesses. Zonal Council that was there established in the Act of Parliament and the State Reorganization Act. While forming this zone, several factors of the taken, which is including the division of country, river system, and the communication and cultural and linguistic effect. So the Zonal Council consists of the following: Home Minister, Chief Minister, two other minister, administrator of the each union territory. Zonal Council are the advisory person nominated the Planning Commission, Chief Secretariat of the government, and the Development Commissioner. So the Home Minister of the central government is the common chairman and 5 joint council, and each of the chief minister act as a vice chairman of this council in the rotation. So General Council aimed at promoting cooperation and coordination between the state, and they discuss the make recommendation regarding the economical and the social plannings to achieve the emotional integration to help arresting the growth of the consciousness regionalism and to help the removing the after effect of separations of the cases of reorganization to enable the center state to the social exchange of the idea to cooperate with each other successful speedy execution to secure some kind of political equilibrium. So Northeastern Zonal Council that was a 1971 Assam, Mizoram, Manipur, Sikkim, and that was the function are the similar those of General Council, which few addition it has founded the unified coordination. North Jammu Kashmir, New Delhi, Central, and Eastern, Western, and Southern. So that was a public act and record of judicial proceeding. Adjudication of the interstate river. 263 is for the interstate council. 301 for the trade. 302 power of the parliament to impose the restriction on the trade. 303 restriction of the legislation power for the union and the state. 304 restriction of the trade. 305 saving the existing laws. 306 power of the certain states, and the 307 appointments of authority for carrying the purpose of the trade. Now next is emergency provisions. So emergency provision are considered the part 18th of the constitution, and that was the article 352 to 360. This provision central government to meet the abnormal situation effectively rational behind the incorporation of these provisions. Constitution safeguard the sovereignty, unity, integrity, and security of the country. During the emergency, the central government become the all-powerful in the total. It convert the federal structure unitary, a formal amendment, and this kind of transformation was to during the emergency is unique feature. All federal system, including American, are placed the light would be the federalism. No matter what circumstances, it cannot change its form. It can never be unitary. On the other hand, Constitution of India can be both unitary and the federal requirement of these circumstances. In the normal time, it is framed the work for the federal system, but in the time of emergency, it is so designed as make the work for the unitary system. An emergency due to the war, external aggression, armed rebellion is known the national emergency. However, the Constitution employed the expression proclamation of denotes an emergency due to the failure of constitutional machinery in the state is known as a presidential rule and constitutional emergency. However, Constitution does not use this. Financial emergency 360 ground of declaration. President can declare national emergency when the security of India or the part of it are rebellion. It may be noted that President can declare national emergency even before the actual occurrence. The President can also issue the different proclamation of war, external aggression, armed rebellion, imminent danger. So whether or not there is a proclamation already issued. So proclamation of the operation, this provision was the 38th Amendment. When a national emergency declared on this ground of war and external aggression, external emergency on the other hand, when they declared the ground of the armed rebellion, it is known as internal emergency. Proclamation of the national emergency may be applicable to the entire country. 42 Amendment enabled the President for the national emergency. Originally concern mentioned the internal disturbance, national emergency, but expression was too vague. So 44 Amendment was armed rebellion by the internal disturbance, and this is no longer possible declared a national emergency. Internal disturbance as was done and Congress government of India, the President however can proclaim a national emergency only after receiving a written recommendation of the cabinet, and this means that emergency can be declared only the concurrence of cabinet, not merely the advice of Prime Minister. So this Prime Minister Indira Gandhi advised the President to proclaim emergency, and the cabinet was informed the proclamation after the complete 44 Amendment introduced the safeguard that eliminated any possibility of the Prime Minister alone taking the decision. 18 Amendment was made the declaration national emergency immune from judicial review. So we can't go for the judicial review, but the provision of 44 Amendment Minerva Mill case was proclamation of national emergency can be challenged in the court. In the 44 Amendment, it was told that it can be challenged in the court and it can be modified, or declaration was based on the wholly extraneous. Parliamentary approval of the duration. The proclamation of the emergency must be approved by both the House of Parliament within the 1 month of the original. The period allowed the approved by the Parliament and reduced by 44 Amendment. However, the proclamation is issued time and Lok Sabha has been dissolved. Dissolution of Lok Sabha take place during the period of 1 month without approving 30 days first sitting of Lok Sabha after the reconstitution. If approved by both the House of Parliament, the emergency continue for the 6 month and indefinite periods. So this is provide the periodical parliamentary approval. Also added the 44 Amendment, and Parliament could remain in the operation for execution of the desired resolution of the Lok Sabha take place period of the 6 month of approving the further continuation of the emergency. So every resolution approving the proclamation is continuation must be passed by the other House of Parliament by the special majority, and it is passed by the special majority and majority of the total membership of the House, majority of not less than 2/3 of the member of the House present and voting. A special majority provision was introduced 44 Amendment. Now proclamation, that was proclamation of emergency may be revoked by the President at any time. Further, the President must revoke the Lok Sabha and resolution. Again, 44 Amendment could be there. So 44 Amendment also provided where 1/10 of the total member of the Lok Sabha give written notice to the Speaker. So 1/10 member will give the written notice to the Speaker, and a special sitting of the House should be held within the 14 days consideration of the disapproving this proclamation. The first one is required to pass by the Lok Sabha, while the second one needed to the pass by House of Parliament. The first one adopted the simple majority, while the second one needed to the special majority. So now the effect of national emergency on the center-state relationship, on the Lok Sabha and the State Assembly, and on the fundamental rights. So effect of this is during the national emergency, the executive power of the center extend to the directing the state regarding the manner in which its executive power is exercised in normal time, and center can give the executive direction on state only the certain matter. Center become entitled to execute the direction any matter. Now legislation. During the national emergency, the Parliament become empowered to make law on the subject of the state list, and the Parliament does normal distribution of legislation power between the center and the state are not suspended. The national emergency become the incorporate in the 6 month. Notably, while a proclamation of national emergency is operation, the President can issue ordinance on the state for also. The further the Parliament can confer the power and they impose the duty upon the center and the officer for the authority respect to this matter. The 42 Amendment of the provided that two consecutive mention about extend not only state where the emergencies operations. Finance. While the proclamation national emergencies operation, the President can modify the constant distribution of revenue between center, and this means the President can either reduce the cancel the transfer of finance and modification till the end of the financial year of emergency. Now the effect of life of Lok Sabha, while the proclamation is there, the extended beyond the normal term, so 1 year at the time, and however the extension cannot be continued beyond the period of 6 months after emergency has been passed the fifth Lok Sabha. Similarly, the Parliament may extend the national emergency for the each time for the 1 year. An emergency subject to the maximum period of the 6 month. Okay, so the effect on the fundamental right, Article 358 and 359. The rights deal with the suspension of fundamental right of 19 and except the 20 and 21. The suspension of fundamental right under 19, that was when proclamation is made, the fundamental right is automatically suspended, no separate order needed. While the proclamation is operation, that state is freed from the restriction. Other words, the state can make any law for the take executive according to abridging taking away the sixth fundamental right. Any such law executing action cannot be challenged on the ground of inconsistent with the fundamental right. When the national emergency ceases, the Article 19 automatically will be removed and the extent of inconsistency will be there. So the emergency, this means the legislation and executive action taken during the emergency cannot be challenged. 44 Amendment restricted the scope, and that was firstly the sixth fundamental right can be suspended only the national emergency is declared on the ground of external aggression and not the armed rebellion. Suspension of fundamental right, Article 359 suspend the president of the suspend right to the move any court for the fundamental right during the national emergency. The fundamental right of the not suspended, but other word this said that right can be suspended but right to seek the remedy. The suspension of the enforcement relate to only those fundamental rights that are specific. The suspension could be for the period during the operation of emergency or the period is mentioned there. While the president order is forced, the state may make any law, can take any executive actions during this specific fundamental right. Any such law or executive action cannot be challenged on the inconsistent with the specific fundamental right. 44 Amendment restricted the Article 359 and firstly the cannot be suspend the right. Article 220 and 21, in other words, right to promote respect to the violation of the offense and right to life and personal liberty, that only those have which related with the emergency protected, so this can't be suspended. Distribution between the Article 358. Article 358 is the fundamental right and 19 only, where the Article 359 is 10 to all the fundamental rights. 358 was automatically suspended by the fundamental right Article 19 as soon as emergency declared. On the other hand, 359 does not automatically suspend any fundamental right. It only empowers the president to suspend this for this right. Article 358 operates only the external emergency and internal emergency declared on the 359 as the armed rebellion, and the Article 358 suspend fundamental right under the 19. 359 suspend enforcement of fundamental right for the period specific. 358 extend the entire country, and 358 is suspend Article 19 completely, but 359 does not empower to suspend 20 and 21. 358 enable the state to make any law to the executive action inconsistent with the fundamental right. Article 19 while enable the state to make law for the executive action. Declaration of made for 62, 75 and 7 national emergency on the ground of Chinese aggression, and second proclamation was national emergency made during the national emergency made both the second third proclamation was also there, and first two proclamation was made the ground of external aggression, and third proclamation was in 1975 made the ground of internal disturbance, so that was the armed forces against the discharge of duty. Emergency was internal emergency proved to be the most controversial, and in 1977 emergency the Congress party Indira Gandhi lost and Janata Party came, and this government was appointed the Shah Commission to investigate the circumstances that warranted the declaration of emergency, and the commission did not justify. Now 44 amendment was introduced a number of safeguards against this emergency. Ground of imposition. Article 355 imposes duty on the center to ensure that government of every state carried out accordance with the constitution. It is the duty of the performance of which center take the government under Article 356 in case of failure of this. Present rule can be proclaimed for the ground of mentioned article Article 356 empowers the President to issue proclamation if it is satisfied the situation arisen that was accordance with the provision of Constitution. Notably, the President can act either of the report of the governor. The Article 365 say that whether a state fails to the comply with or give effect to any direct from the center, it will be the lawful for the President to hold that situation arisen in the while government cannot be arisen accordance with the Constitution. Parliamentary approval. A proclamation imposing present rule must be approved by both the House of Parliament within the 2 months. And however, if the proclamation of present rule is issued as a time Lok Sabha has been dissolved or the dissolution Lok Sabha take place during the 2 months and the proclamation of survival of 30 days of the first sitting. Approval of both the House of Parliament present rule is in the 6 months. It can be the extent of the maximum period of the 3 year and with the approval of the Parliament every 6 months. However, if the dissolution of the Lok Sabha take place during the period of 6 months without approving so far the present rule, then the proclamation is the survive until 30 days of the first sitting. Every resolution of the proclamation of present rule continuation can be passed by the either House of Parliament only the simple majority and a majority of the number of the House present and voting. 44 Amendment Act introduced a new provision for the restraint of the power Parliament extend to the President and provided the beyond 1 year. So the present rule can be extended by the 6 month. Proclamation of the National Emergency Whole of the India Election Commission must certify the general election to Legislative Assembly is not conducted. So the proclamation of the present rule may be worked the President at any time. Now the consequences of the present rule. He can take up the function of the state government for the power vested in this. He can declare that power of the state issued can be exercised according to Parliament. He can take all the necessary steps for the suspension. Therefore, when the present rule is the president diminish the state and the minister headed by the chief minister, and this is behalf of the president carries on the administration with help of the chief secretariat. This is the reason why a proclamation under this popularly known as imposition of the rule of the state. The parliament can delegate the power and the parliament or can delegate the president. There is a the Article 365 say that whenever a state fail to comply with the give effect of an direction from the center, it will be lawful for the president to hold that a situation arisen in which government of the state cannot carry accordance with the provision of Constitution. Parliament approval and duration. A proclamation imposing present rule must be approved by both the houses. A proclamation rule is issued as when the Lok Sabha has been dissolved or dissolution of the Lok Sabha take place during the period of 2 months. Without approving now 30 days are the first sitting and its recommendation is approved by Rajya Sabha. If they are approved by both the House of Parliament, it can be extended to the maximum period of the 3 years with the approval of Parliament every 6 months, and that was Lok Sabha take place during the period of 6 months. Then proclamation was in a 30 days first sitting, and after this provided the Rajya Sabha. So every resolution approving the proclamation of the rule of constitution can be passed by the either House of Parliament only the simple majority, and that was mentioned. 44 Amendment introduced the new provision for the restraint of the power Parliament to extend the proclamation of the President. It provided that beyond the 1 year, the present rule can be extended to the 6 month. Proclamation of National Emergency Whole India and Election Commission must be certified, and he can take the function of the state government power vested in the government, and he can declare that power of the state are exercised according to Parliament. He can take all the necessary steps, suspension of the rights and all that. Therefore, the present rule is a headed like it will be applied only after the consultation of the CM and its ministry is advising to the President. And Chief Secretary will also help and advise for this. And now there is a national emergency and the present rule. National emergency, it can be proclaimed only when the security of India is threatened, war, external aggression, armed rebellion. During the operation, the state execution and the legislature continue to function, exercise the power, and that the center gets the concurrent power. Under the Parliament can make law on the suspend subject enumerated the state list only itself cannot be delegated to the power. There is no maximum period prescribed the operation, but it can be go for the indefinitely with the approval of parliament in the 6 month. Under this, the relationship of center with the whole of the state undergo modification. Every resolution of approving is a continuation must be passed by the special majority. So this is what the special majority Lok Sabha passed the resolution, its revocation. President rule, that was it is the government state the carried out accordance with the provision of the constitution. So during the operation, the state executive dismissed and it's either suspended. The president administered and the state through the governor. Parliament will go for the brief in the execution of this. Under like the parliament can delegate the power to make the law for the state, and so far the practice has been the president to make the law for the state constitution with the member of parliament. There is a maximum period prescribed is a 3 years, and thereafter it must be come to the end of the normal constitution machinery. Under the relationship of only state under the emergency with the center undergo, every resolution of parliament approving proclamation is passed only by the simple majority. It is no effect of fundamental rights, but there is no such provision. It can provoke by the president own. The president can promulgate when the parliament is not in session. So a law made by the parliament or president or the any specified authority contained to the operative. This is the known as Article 356 of the President Rule imposed 100 occasions and the average twice a year. Further, on the number of the occasions, the President Rule has been imposed arbitrary manners, and hence this is the become a most controversial. So there was now most of all the state has been both under the President Rule. Generally, the election held in the 1977 after the ruling Congress party lost the Janata came. The new government headed by Moraji Desai imposed the President rule, whereas on the ground of the assembly was no longer represented. But when the Congress party returned in the 92, the President rule was imposed in the three BJP like Madhya Pradesh, Himachal and Rajasthan, and implementing sincerely has been imposed center and religious. Now the landmark judgment of Bomai case is Supreme Court upheld the validity of the proclamation. Secularism is a basic feature of the constitution, but the court did not uphold the validity and present rule of Nagaland, Karnataka and Meghalaya. Dr. Ambedkar, while replying to the critics of the provision, hoped that was a drastic power and that was 356 would be dead later. So the interaction of the center must be deemed to become an invasion of sovereign authority, and the fundamental provision of we must have a federal constitution and provision. So under the obligation which is the constitution imposed upon, the proper things ought to be the expect of the article will never be called in operation. The scope of judicial review, Article 38 Amendment of 1975 safeguard the president to invoke the conclusive which is challenged in the court, and the Bomai case was followed led down the Supreme Court president rule in the state. The president proclamation was ruled subject to judicial review. Safeguarding the president must have the relevant material. Burden lies the center, and the court cannot go into the correction of material. If the court hold the president proclamation unconstitutional, then it will be the invalid. When the general election to the assembly, no party secure the majority, so that was the hung assembly. In the hung assembly situation, Sarkari Ayog was telling about imposition of the 356. When the party having majority in the assembly decline for the minister and the government cannot be according to the coalition government, and where the minister resigned after the defeat in the assembly and no other party willing to the able to the minister commanding. When a constitutional direction of the center government is discharged in this government, and internal subversion where for the example acting against the constitution and the physical breakdown of the government. So when the ministry is resigned and when the governor makes the own assessment of the ministry, imposition of the president rule, when there is a ruling party enjoying the majority support and the mass defeat, internal disturbance not amounting to the internal subversion, maladministration, and when there is a power is used to sort out the inter-party problem. So the ground of declaration, Article 360 of the empower the president to proclaim the financial emergency. 38 amendment made for the president declaring the financial emergency final and conclusive. not questionable. 44 Amendment Act was the satisfaction of President beyond the judicial review. So the Parliament approval of the duration. There is no maximum period prescribed and the repeated parliamentary approval is not required. So resolution approved by proclamation of emergency can be passed by the other house of parliament with a simple majority or majority of the house present and voting, and the proclamation of financial emergency may be revoked to president any time. Such proclamation does not require a parliamentary approval. Financial emergency issued by the Lok Sabha dissolved, and now there is a without approving 30 days of the sitting to the indefinite period. It is also go for that. Now the fact of financial emergency, the direction provided by the center and the state. Direction of president may be deemed necessary to adequate purpose. A reduction of the salary allowances of the person, the reservation of the whole money bill or other financial bill for the conviction of president. President may issue direction for the reduce the salaries and allowances of the judges. So now there is a critics of the emergency. Federal character of the constitution is destroyed. Power of the state and the both union will entirely concentrated. The president will become a dictator or financial autonomy of the state will be nullified. Fundamental right will be become the meaningless. So these are some reasons why we can't go for this. So proclamation of emergency 352. 353 is effect of emergency. Application in 354 for the distribution of the revenues. 355 is duty of the union to protect the state against the external aggression and internal disturbance. 356 provide in the case of failure of constitutional machinery. 357 exercise the legislation power under the proclamation. 358 suspension of the article, and 359 is suspension of the rights. 360 was the proclamation of financial emergency. So these all articles are related to this.